Okay, everyone, we'll get started today. We still might have a few people joining, but welcome to our August Lunch and Learn series. Today, we're going to talk about how to balance public engagement with maintaining control over your board meetings. I think this has been an issue that many local boards have been confronting over the last year and a half, especially. And so we thought it was a timely topic, especially as we're getting started with a new school year. Before we start, I should say, we don't have a significant amount of participants today, so that hopefully will give those that are watching a lot of ample time to ask whatever questions you want. Feel free to ask questions throughout our discussion today. You can ask questions by using the Q&A feature on your Zoom taskbar. You can use the chat feature if you're having some technical difficulties, if you can't hear me, or if you can't see my the slides. Otherwise, use the Q&A feature to ask questions. And we'll have some time left at the end as well for questions if you want to wait till then. Okay, so before we start digging into the topic, I wanted to kind of set the stage a little bit for our discussion. And these are all things that our board members and administrators and school staff already know, but I think it's worth mentioning them to kind of set the stage. So as we all know, the demands on public education in our local school boards are increasing more than ever. On top of that, we have our state lawmakers and our Congress in Washington putting more and more strings on education funding as kind of an incentive to change or to demand, what they would like to see as better performance of our public schools. And then we also have more and more calls for school choice and for education reform. And then lastly, more and more our local communities and our taxpayers are starting to question whether they're getting a sufficient return on the investment of their education tax dollars. So we kind of have that bucket of challenges that all of our local boards and educators are dealing with on a day-to-day basis. And then meeting those challenges with the ever-increasing demands for accountability and teacher quality with less funding is becoming more and more difficult for our local boards to handle. And all of the challenges that our public education are facing, the blame for those largely fall on our local educators and our school boards. And then the weight of all of this, the negative public perception, is compounding the effects of those demands. So that's kind of the state of public education and local school boards these days, especially as we're continuing to deal with the COVID-19 pandemic. And so I thought it would be helpful to kind of to talk about these or mention these so that we can understand why the topic we're talking about today is so timely and important. Before we get into the how to balance public engagement with while conducting orderly meetings, I thought it would be helpful to go over a few board meeting basics. So what do we mean when we're talking about board meetings? So the law is pretty clear on what constitutes a meeting for open meetings requirements purposes, and it's quite broad. It's any formal, informal gathering, whether that's in person or through electronic means, of a quorum or more of a governing board of a public entity regarding public business. So that's the definition of a public meeting straight out of the Century Code. And of course, a quorum equals a majority or more of the elected board members. Or if we're talking about a board committee or a subcommittee, it's a majority of the committee or subcommittee members. And then the governing body is the board, as well as a committee and a subcommittee. And why that's important is it's underpinning the the fact that not only do our school boards have to comply with open meetings requirements, but also any board committees and subcommittees that are tasked with responsibility by the board. In order to be a meeting under North Dakota law, it has to be regarding public business. So what do we mean by public business? North Dakota law defines public business very broadly. It essentially encompasses all matters that relate or may foreseeably relate in any way to the performance of the public entity's governmental functions. So anything that could possibly relate to what school boards and school districts do in their operations would constitute public business. And then in addition to that, any matter over which the public entity has supervision, control, jurisdiction, or advisory power, or the public entity's use of public funds. So you can see that, you know, anything that relates in any way to the business of a school district, if it is, you know, occurring or being discussed with a quorum or more of a board, of a school board, board committee, or subcommittee, you're going to have a meeting taking place, and you'll need to comply with the open meetings requirements. I'm not going to go through the open meetings requirements in terms of notice and public access, not in detail. We'll focus a little bit more on the public access piece of things, but some of this is good review to kind of, you know, underpin the discussion that we're going to have today. As we all should know, meetings can occur in a number of different formats and venues. Obviously, we can have meetings that occur in person. We can have meetings by telephone conference call, via video conference, but we also can have meetings via group text messaging, via email, when you reply all, and a series of communications amongst a quorum or more of the board. These last three are the problematic meetings. These are the ones that are likely going to trigger a violation of the open meetings rules, because it's likely that you're not providing advance notice of these meetings in compliance with the law. And there's really not a way to provide public access. So these last three that you see here are kind of the no-no, but meetings can occur in those formats. A public entity meeting, so a school board meeting, is presumptively open to the public. That is the general default rule, unless the subject matter falls within a specific exemption from the open meetings laws, or if a confidential meeting is required by law. So the key here is that all meetings of a public entity's governing board, so the school board, a committee, a subcommittee, have to be an open meeting, accessible by the public with advance notice, unless there's a specific exemption provided in law, or if there's an ability to close a portion of the meeting for executive session. Like I said, I'm not going to go into, this isn't, the purpose of this, our discussion today isn't to rehash the open meetings requirements, but I think kind of to understand the public access requirement of it and how that plays into community engagement is kind of why I thought we should talk about this today. So who has the right to attend a meeting? Every person has the right to attend a school board meeting, regardless of their interest in the meeting. There's a small caveat to that when it comes to your school administrator. I think a board has some control over whether they want a school administrator or a business manager to attend a particular meeting. I think that is going to be so few and far between that it's not really worth discussing today, but it's a small caveat. The board can prevent a superintendent from appearing, for example, at a meeting, a board meeting, in their capacity as a superintendent. Superintendent may still appear as an audience member, a member of the public, but they wouldn't be there in their official capacity if the board found that necessary in a given situation. But again, that's going to be so few and far between that it's probably not worth discussing any more than that. We kind of have a mantra here at North Dakota School Boards Association that we say all the time to kind of underpin what a school board meeting is and what it isn't. A school board meeting is not a public meeting. It is a business meeting that's held in public. The public has a right to access the meeting and to observe, but they do not have the right to participate or speak. It's not a town meeting. It's not a public forum unless the board chooses to make it to open it up to public comment or input. Another thing to keep in mind is that a school board has the right to control the decorum of a public meeting. So you have the right to do that. You have explicitly under North Dakota law, school board has the right to maintain control and custody of all school property. So if you're holding a school board meeting on school property, you get to control and the decorum and the meeting at that facility. You also have the right to control the decorum in the meeting. You maintain control over that meeting at all times. This is kind of a quite common question that I get. Who can call a meeting? And that's usually going to be a special meeting of the board. This is explicitly addressed in North Dakota law, specifically in section 15.109-30. The law provides that the school board president has the right to call a meeting of the board. In addition to that, any two board members may call a meeting of the board. So for example, if the school board member wants an issue to be heard at a meeting and the school board president says, I'm sorry, I don't think it's appropriate or the timing isn't right to have that item discussed or added to the agenda of this particular meeting. If that board member who requested the meeting gets together with another board member, the law allows them to call a meeting for a particular purpose. So that's one way that board members who are not the school board president to get an issue heard and put on the agenda of a meeting. We encourage our board presidents to, consider requests from their fellow board members to add an issue to the agenda. But at the end of the day, the school board president, decides what's on the agenda unless two school board members get together and request the meeting. And we'll talk about meeting agendas in a bit. But anytime a special meeting is called either by the school board president or by any two board members, written notice of the meeting has to be provided to each school board member in order for that meeting to occur. And then you would treat it just like any other special meeting of the board. Okay, so who determines the meeting agenda? So the board president, typically it's going to be the board president with assistance from the superintendent. That is going to be outlined in board policy typically. If you have NDSBA's template policies, that policy would be BCAA. And that lays out, how the agenda is created and the pre-meeting procedures with respect to the agenda. As I mentioned before, what about requests from other board members to have an item added to an agenda? Again, we encourage our board president to consider those, and fairly consider them. But at the end of the day, the board president, with the assistance from the superintendent, has the ability to determine the agenda. The only caveat to that is if 2 school board members request a special meeting, and then in essence, they have the ability to add an item to an agenda, meeting agenda, in that way. What about adding to the agenda at meetings? So this is also a common question that we get. So basically, the law allows for items to be added at regular meetings upon majority vote of the board. The only caveat to that is if the item was anticipated or foreseeable at the time that the notice of the regular meeting was posted, you might be that might limit the board from adding that to the agenda at the meeting. So that's the only caveat, but generally you're going to have the ability to add items to the regular meeting agenda at the meeting upon majority vote of the board. You are not able to add items to a special meeting agenda at the meeting. You have to have all topics that are going to be discussed at the special meeting in the notice that's provided in advance of the meeting. So you are restricted in terms of adding items to the agenda at the meeting. The other thing to keep in mind is that you have to have, North Dakota law requires that all executive sessions anticipated or expected at a meeting, regardless of whether it's a regular or special meeting, have to be included in the notice that's provided in advance of the meeting. So you can't add executive sessions at a regular board meeting or a special board meeting. Who presides over meetings? Well, the board president is by law assigned to preside over board meetings. If the board president is absent or unable to be present by phone or otherwise, then typically, then the vice president, if you have elected a vice president to your board, would preside over the meeting in the board president's absence. What about if the vice president and the board president are both absent, and that has occurred many times, then generally the most senior board member present would preside over the meeting. But that's typically provided by policy. And that board policy, if you have our templates, is the BBBA policy. That's going to be your board officers policy. That essentially directs what happens when your presiding officer, your typical presiding officer is not at the meeting, and so you would follow that direction. Okay, so let's talk about the board president's duties at board meetings, and this is important. Will become very important when we start talking about public engagement, especially public engagement at board meetings. So the board president calls the meeting to order. That's kind of the first thing once the meeting starts. And the board president is also tasked with keeping the board on track with the agenda. So making sure that you don't get off track, that you don't get out of order, that items that are not on the agenda are not discussed. So you want to make sure that as a board president, you're keeping the board on task with the agenda. Kind of the biggest thing is making sure that you maintain decorum and order at the meeting. And this can be pretty difficult depending on the issue, especially if you're dealing with a controversial issue at the board meeting. But at the end of the day, that responsibility falls on the board president, or if the board president is absent, on the presiding officer. And that would be the case with all of these that we're mentioning. The board president or the presiding officer would also make sure that Robert's Rules of Order are followed. The law doesn't require school board members to follow Robert's Rules of Order. That is typically designated by board policy. So the board will, by policy, say we are going to follow Robert's Rules of Order in conducting our board meetings. So it would be incumbent on the board president or the board presiding officer to make sure that the Robert's Rules of Order generally are being followed at board meetings. You also are going to be tasked with making sure that board members and others participating in the meeting are speaking in turn. If someone is out of turn or out of order, it's going to be on the board president or the presiding officer to stop the speaker and let them know that they're speaking out of turn. And then one of the most common questions that I get when it comes to board president duties at board meetings is whether board presidents can make motions, whether they can second motions, and whether they can vote on everything. The law doesn't speak to this, okay? So if your board policies are silent, the board president is going to be able to make motions, they're going to be able to second motions, and they're going to be able to vote. Many districts adopt a policy in their board officers policy. So let me go back. Your BBBA policy are going to address whether the board president can make a motion or second a motion. Board policy should never prohibit a board president from voting on a proposed action unless there's a conflict of interest, which would be dealt with under those specific rules. But a board president has a vote just like any other board member. They're not just there to break ties in voting. There is no such thing in school boards to break ties. So in terms of school board votes. So that's not a thing. Board presidents, just like any other board member, should be voting on each and every proposed action unless there's a conflict that would prohibit them from doing that. But there are board policies that do limit the board president's ability to make motions or second a motion. But you can certainly choose to not restrict the board president in that way. I would be remiss if I didn't mention that when you are electing your officers at your annual meeting in July, it is very important to keep all of these duties in mind to make sure that you are electing an appropriate board member to serve as your board president. It is not an easy job. It can be tough to maintain order at a meeting. And so you want to make sure that you're factoring that in when you're electing your board officers to make sure that you have someone that's going to feel comfortable carrying out these duties, that they understand what their duties are going to be as the board president. And so you're making sure you're picking the right person. Okay, so now that we've kind of gone through a little bit of board meeting basics to underlie the public engagement in board business discussion, let's move on to that. So I found this graphic online when I was researching kind of effective school board characteristics. And I think this describes the key work of school boards quite well. Obviously, like the key thing that school boards, the purpose of school boards is to increase student achievement in your district. And then kind of to achieve student achievement, it takes, establishing a vision, being accountable, setting appropriate board policy, building appropriate relationships, and what we're going to focus on today is community leadership. How do you engage the community in helping the school board do its work of increasing student achievement? So, is public engagement important? I hope all of us agree that yes, it is important. At the end of the day, although it can be tedious, it's a necessary factor in local public education and school board governance. But why is it important? And in 2019, the National School Boards Association Center for Public Education researched and reviewed a number of different studies that looked at effective public school board governance. And one of the top 8 characteristics of a successful and effective school board is the school board's ability to engage the community as collaborative partners in the goal of increasing student achievement. So in other words, public engagement, effective public engagement, is a key characteristic of a successful and effective school board. But as I'm sure all of us know, that is becoming more and more challenging, especially with what we talked about at the outset, all of the demands that we're seeing from, every different place. It's becoming more challenging. So why boards decide not to be involved in community or public engagement? And these are kind of some of the key things that we hear often, or some reasons related to these. And we sometimes echo them, depending on whether it's appropriate in a given situation to seek out public input or feedback on a particular issue. So sometimes these are good reasons, but as I'll explain on the next slide, they don't really hold water for the most part. So some of the reasons why boards are hesitant to be involved or decide not to get involved in public engagement or community engagement. One thing that's a common reason is we were elected to represent the community and they trust us to make appropriate decisions. We don't need to keep asking them for their opinions. So this is kind of the community voiced their, gave their input at the ballot box, and that's where it ends. Another thing that we hear, or that I think some boards believe, is that the public really isn't interested in the work we do. And I think sometimes that's not an unreasonable way to think, because I think sometimes some of the things that we think that is really important, like student achievement, academics, sometimes those get overshadowed by kind of other issues that are important, but maybe not as important as student achievement or academic success or student readiness, like athletic sports or, kind of political issues that really aren't really relevant in the day-to-day operations of school districts. So sometimes it can feel like the public really isn't interested in the important work that school boards do. Another reason is that a board member may say, I was elected to be a school board member. I'm not a public relations expert. I don't have the wherewithal to know how to effectively communicate with the public in a meaningful way. The other thing is only engaging the public when you need their support for something specific, like a bond referendum. That's kind of where boards stop when it comes to community engagement. And then another common thing that we hear is involving the community is not my job, it's the administrator's job. So we will leave it up to him or her to do. So as I said before, while in the moment some of these reasons might seem reasonable, they don't actually hold water when in the grand scheme of things. And I address each of them here. So when we talk about, well, the community voiced their opinion at the ballot box. They voted me in. I don't have to, they knew, my position on things, or they kind of knew my purpose for getting on the board. So they elected me. So, I've received their vote. I really don't have to worry about going back to them and seeking input. But I think what we have to keep in mind is that not all opinions held by the community are represented on the board. Residents will feel more ownership when they are involved. And it's always much easier for the board to do what they want to do and to accomplish their goals and to increase student achievement when they feel support from the community. And so, I think, again, that initial reason doesn't really hold water. Working alone will not create or sustain increased student performance. When we're presented with complex challenges, we need to actively seek multiple points of view and experiences that will help us come up with better solutions to these challenges. So working alone really isn't going to be the successful way to go. As a board member, everything you do communicates a message. So when you say, I'm a board member, I was elected to be a board member, I'm not a public relations expert, the reality is that you are involved in community relations as a board member, whether you like it or not. And so it's something that you can't avoid. So we need to think about how best to go about it. And are there some things that we can do to make it more beneficial, to make it easier for you, so you aren't expected to be a public relations expert, but what are some of the things that you can do to have beneficial community engagement? And then getting to the selective public input issue. So only going to the public when you need their support. As we all probably know, people do get wise to this selective public input strategy, and then that can build resentment for the board when you're only asking for their opinions when you want something in return. And so that can kind of sour the relationship with your community if that's the only time you're allowing them to provide some feedback or input. And then lastly, yes, the administrator does have a role in helping the district engage the community, but the board is the governing body of the school district, and it's crucial for the board to maintain that leadership role when it comes to community engagement. So just handing it over to your administrator is really not going to be in line with the board being the leader of the district in terms of kind of overall vision setting, overall goal setting. Okay, so now that we've talked about why community engagement, public engagement is important, and why we should make efforts to increase community engagement, or at least plan for it in our board governance operations. What do we mean by community engagement? So it's a two-way process. It's a process of communication between where the board is communicating out its goals, vision, and then also seeking input, feedback, information from the community. And that can be from various segments of the community, like just generally from patrons, maybe in a particular circumstance, parental engagement is more important, or maybe the business community it's appropriate to get them to become engaged in certain issues because they might have expertise that can help the board make important decisions. Community engagement, the purpose of it is to build public support for the district's vision. That's the underlying purpose of it and why it's important to think about and to make a plan for. I liked this. I saw this thing, the best board members create public opinion. So I think that's a good thing to keep in mind, is that, if you're thoughtful about it and you plan for it, I think a board can create the public opinion that it wants regarding its goals and its vision. I really like that perspective. And again, as I've said a couple of different times, making a plan for how you engage your community, different segments of your community, is important. You don't want to kind of leave it to social media or your local media to do that for you. You want to be the leader of that and to be the one spearheading it so that you can control the message rather than leaving it to somebody else who might not really understand what it is that you want the community to know, or they might inaccurately report it, and so now you're having to deal with that. Community engagement is going to build collaborative relationships. And one of the things when we talked about the key work of school boards is building up relationships. And that's relationships in a number of different areas, staff, student, parent, business community, the community at large. Building collaborative relationships is going to help the board achieve student achievement. And then, as I stated before, good public or community engagement requires a plan to inform your community and to seek, seek out their feedback and input in the way that you want to receive it. Okay, so so far I've been talking about public engagement kind of in the broad sense, but what the purpose of today's discussion is really kind of to focus on public engagement at board meetings. And so I'm going to focus on board meetings now. So what public engagement is and what it is not. And so what it is not is that the public gets the right to observe and to access public meetings. They do not have a right to speak and participate, as I mentioned before. Only elected school board members are permitted to make motions, to second motions, debate, and vote. No other person has the right to participate except when the board has solicited and scheduled such participation on the agenda, or if the board chooses to call upon someone for information on a particular item. And that can be school staff or just any other member of the public. The only thing, again, that a non-board member may do is to speak to an issue as prescribed by board policy and when recognized by the board president. So it's important to understand there is no right to speak. Generally, there is no right to speak at a board meeting or to actively participate in terms of others other than the elected school board members. Again, the public is permitted to attend, to listen. They can also record proceedings as long as they're not disruptive, but they can only participate as allowed by the board. So the board has the discretion. They have the power to determine how non-school board members participate in the meeting. And we generally recommend that participation by non-school board members only be allowed in accordance with established procedural policies by the board. And those are typically going to be set forth in board policy. When the board allows a non-school board member to participate or speak at a meeting, it's important that the board inform the speaker that they are not allowed to speak out of turn or be disruptive. They're only allowed to speak or comment pursuant to the authority given to them and the parameters given to them by the board. The board is generally going to have the discretion to determine which issues on which they want to seek public input. So you can decide, well, we're gonna talk about our facility needs at an upcoming board meeting. That might be something you want to seek, give the public an opportunity to comment on. But you may have another issue that comes up, like a hiring decision that maybe you don't want to give the public the opportunity to speak or participate at the meeting on that particular issue. The board generally is going to have discretion to offer or allow participation on one issue and not on others. The other thing too is community engagement does not mean participation at a board meeting. It also does not mean that patrons, parents, members of the community are allowed to harass administration, staff outside of a board meeting on school property by phone or electronically, like by email or text message. The board should take steps to protect their employees and staff outside of meetings as well, because I think we all know that, if a member of the public isn't able to voice their opinion or their thoughts at a board meeting, they often will then contact administration and or staff and maybe peppering them with communications that are disruptive. And so the board will also need to take steps to protect their staff from those types of things. Okay, so let's talk a little bit about what public participation looks like at a board meeting. So like I said before, boards should adopt a procedure for public participation at board meetings. I believe most, if not all of the boards that we serve have a board policy in place that addresses public participation at meetings. And that is typically going to be policy BCBA, and then also the attached board regulation that talks about decorum at public meetings. There's kind of two ways that a non-board member can participate at a meeting. Either they can request to be placed on the meeting agenda, or they can offer comment in a general public comment period that's placed on the agenda. So when we talk about the first method, requesting to be placed on the agenda, that process should be outlined in board policy. Again, BCBA, that descriptor code, that policy is going to talk about that, as well as your pre-meeting agenda policy. That's also going to talk about this. Your policy should require any such request to be submitted in advance to either the board president or the superintendent. And identify the topic or the purpose for the request to be placed on the agenda. And I think our template policy says a minimum of 5 days before the scheduled meeting, those requests have to be submitted. And then at the end of the day, the board president has the discretion whether or not to grant that request. And I would say that there may be a very good reason why you'd want to grant a request for someone to be placed on the agenda, but you want to be careful. Again, you control, as the board, you control public participation at meetings. And so you generally have the discretion to grant or deny those requests to be placed on the agenda. And so I think being very thoughtful about whether it's a good idea to have a specific item placed on the agenda is important. The other thing is, if you decide to grant the request, I think you want to lay out the expectations of the person that's going to be presenting, what the rules are going to be, how much time you'll give them, whether or not the board is going to be able to ask questions or respond to whatever the item is. You have the discretion to set parameters, and you should set parameters and communicate those to the individuals that are going to be placed on the agenda. The second method of public participation is that general public comment period. That's typically going to be placed, I would say most boards have a general public comment period on their regular meeting agendas, and it's typically at the end, but that's not a requirement. It's just a common practice. You can decide whether you want to have a general public comment period at a regular meeting or on a special meeting agenda. There might be a good reason why you don't want to open agenda items up to public comment at a given meeting, but that is within the discretion of the board to allow that type of participation. The board president or the presiding officer, if the board president is not available, is going to be charged with managing that public comment period at the meeting. So making sure that those that are providing comment are following the rules. So the typical parameters are asking each member of the public to state their name and their address. Let them know that they have a specific amount of time. You should be limiting the time, and that they only should be allowed to comment on items that are on the agenda at the meeting. It's not an opportunity for them to just bring up any old issue that they are, that they care about at that particular time. Make sure they understand, and this should be set. These should be voiced prior to allowing members of the public to come up and comment. That they're expected to state their name and address, that they only have a specific amount of time, that they can only comment on items that are on the agenda at that meeting. If they don't follow the rules, they will be cut off and asked to leave the lectern and go take their seat. The other thing I think that some boards overlook for public comment period is whether the board is going to just receive the comments, or if the board members are going to have the freedom to ask questions or to respond to public comments. I think our general recommendation is for the board just to receive the public comments. If it's a general public comment period, just receive the general comments, don't respond, don't open it up for questions. And if you have questions that you want to ask, or if you want to respond, you can do that after the meeting in writing, or you can a board member can give a call to the patron, whatever the case may be. That's our general recommendation. But again, at the end of the day, the board gets to decide kind of how they want to structure that. You should know prior to the meeting how you're going to handle that that public comment period if you allow it. I have a question coming up. It says, on our agenda, we have guests listed, mostly to acknowledge any guests in the meeting. This is before old business on the agenda. Would this be a place for public input, if any, in a regular meeting, or would it be better at the end of the meeting? A good question. So I guess I would say, you guys, what's important is that your agenda is clear. And so the items on your agenda should be clear about what you mean by it, especially if it's a special meeting, because you have to be more specific in your special meeting agendas. So just listing guests on a special meeting agenda is probably going to be a violation of the open meetings requirements. But your regular meeting agendas, you have a little bit less burden to be specific. It still has to be sufficient to give notice, but you don't have to be as specific as you do for special meeting notices. So I think if the purpose of your guests agenda item is to recognize or acknowledge guests at the meeting, which I think is a common agenda item for regular meetings, that should be what that agenda item means. If you want to provide a general comment period from the public comment period, I think it's very typical to put that at the end of the agenda. If your intent is to allow the public to comment on any item on the agenda for that meeting. But again, you have the discretion to structure your agenda. So if you only want to provide the public the opportunity to comment on old business that's on the agenda, then maybe you put a general comment period at the end of old business on the agenda. Or if you only want to allow them to comment on a particular item on the agenda, you would have a general comment period limited to that specific agenda item. So, bottom line is the board gets to structure the agenda the way they want. They can include a general comment period for the entire agenda, or limit it to old business or to one specific agenda item. So I hope that answers your questions. Good question. Okay. Oh, one thing I wanted to mention is that I said generally the board has the discretion to determine when and if general public comment or public participation in general is appropriate for a given meeting. There are some limited exceptions related to public hearings. So for example, when you're doing your 3 to 5 year planning meeting, you're required to seek public input for your 3 to 5 year plan. That's specific in the law. If you're developing a safety plan, and that's a recent addition to the code, I think 2 sessions ago, you're required to get public input on a safety plan. And then the other more common obvious one is your budget and tax hearing that you have to hold each fall, is that you allow the public is allowed to comment on your budget and tax levy. So those are just a few of your the caveats. You still have the ability to set rules in terms of decorum and kind of how you're going to allow the public to comment at those public hearing type meetings, but you don't have the discretion typically whether they get the ability to participate or not. That is established in the law. Okay, so some comments on conduct or remarks that are out of order at a meeting. And this is something that all boards should be prepared to deal with. Any undue interruption or other interference with the orderly conduct of the meeting cannot be allowed and should not be allowed by the board. And so if somebody is being disruptive or interfering, maybe yelling out from the audience, or if a board member is speaking out of turn, it's important for the board president or the presiding officer to, recognize that they're out of order or they're being disruptive or interfering, and ask that conduct cease. Obviously, defamatory or abusive remarks are always out of order. And if those types of remarks are made, it is incumbent upon the board president or the presiding officer to call that out immediately and to ask that the individual refrain from making those types of remarks. A school board in an open meeting, if they are making defamatory remarks, you can be held liable for those remarks. So you can have a defamation claim asserted against the school district if defamatory remarks are made at a board meeting. I think it's also problematic if the board allows for defamatory remarks to be made without taking any action. If a speaker has been allowed to speak, but they are speaking out of turn or they're engaging in improper conduct, the board president or the presiding officer has the authority to terminate that speaker's privilege. Again, the speaker is speaking based on the authority provided by the board. And so if they speak out of turn or engage in improper conduct, that privilege can be revoked. So again, the board, it's important for the board to maintain decorum at the meeting. Any person that's being persistently disruptive of a school board meeting can be removed from that meeting by order of the board president or presiding officer. What is meant by persistent? I think it doesn't necessarily have to be multiple disruptive acts in order for the board president to remove that individual. I think one particularly egregious disruptive action can be enough to tell for the board president or presiding officer to say, I'm sorry, you need to leave the meeting. But usually best practice is to at least give the person a warning first. Give them the opportunity to change their behavior and to act accordingly. And if they don't, then you can pull the trigger and ask them to leave. Always remember that if you are anticipating disruptive comments or conduct at a meeting, law enforcement can be on call, maybe even in the meeting, and they're in the event that you need assistance to remove individuals. And if you don't have them there, if you're not anticipating disruptive comments, you can contact law enforcement and ask that they assist in removing an individual if that becomes necessary. Okay, so we kind of talked about speakers and public participation, but it's oftentimes where at meetings, if you're discussing a particularly controversial issue, or even if you're not even anticipating that it's controversial, sometimes you get audience members that aren't exercising proper decorum. And so it's important for the board to set rules of decorum and expectations of decorum for the audience. So clapping, applauding, heckling, or verbal outbursts in support or in opposition of a particular issue should be discouraged. And that should kind of go without saying, but I think if you should have these types of things set out in board policy. I believe our BCBA board regulation addresses these rules of decorum for audience members. So, that's obviously helpful to have it set forth in a policy or regulation, but it's also maybe a good idea to have like a list of rules of decorum posted at your, your typical meeting location, so that members of the public can see what's expected of them. If they're acting out of order, you can point to it and say, we have established rules of decorum. We expect audience members to be respectful and to not be disruptive. And so then you can point to the wall and say, hey, here, this is what we expect of you. If you have an audience member or members that are being disruptive to the order of the meeting, the board president or the presiding officer has the authority to recess the board meeting when that conduct starts to be disruptive. So if you should try to maintain order, try to get the person to act accordingly, to follow the rules. But if they don't, or if something gets out of, a little out of control and you can't gain control of the meeting, the best thing to do is to recess the meeting. We've even had circumstances where, the board has recessed the meeting and they'll try to come back, call the meeting back to order, and it happens again. And I think, at the end of the day, if you cannot maintain control of the meeting despite recessing, you can adjourn the meeting and deal with the remainder of the agenda items at a future meeting. You have that ability to recess the meeting and to even adjourn the meeting if that becomes necessary. This should be addressed in your policy or regulation, but signs, placards, banners, or items used to display an audience member's message can be allowed, but if they are, they shouldn't be, I have dispute, but it should be disrupt meeting or interfere with somebody else's visual rights or visual ability to see the board members or the board meeting. You should generally prohibit audience members from approaching the board table, particularly during the meeting while it's called to order, unless the audience member is given permission by the board president or presiding officer to approach the board table, or to approach, if you have a lectern where you allow individuals who are speaking to speak at, they shouldn't just approach. They should have the permission of the board president or the presiding officer to approach. So that's all I have for today. Looks like we have a question. Okay. We have a board member who is abusive to another board member in and outside of meetings. Is there action that can be taken against the abusive board member? Censure doesn't work. The same board member also claps and whoops it up when the public presents comments she agrees with. What actions can the board take, if any? Again, censure means nothing to this person. So this is kind of just the kind of the worst case scenario when it comes to boardmanship. When you have kind of a rogue board member that just, despite your informal efforts to get them to kind of, maintain decorum at the meeting, what can you do when those efforts fail? I would hope that, and it sounds like in this case, if you're already at censure, you've likely tried informal methods, maybe having an informal conversation between the board president and this board member, and it kind of is a progressive thing, almost like a progressive discipline thing. But, if somebody, a board member speaks out of turn at a meeting, depending on the situation, most of the time the board president should call that out immediately when the board member is acting out of order at the meeting. Call them out right up there and say, I'm sorry, you're out of order. Or, board members should be refrain from clapping or, indicating support or opposition to a particular comment. That's improper, that's out of order. And the board president should address that promptly at the meeting when the conduct occurs. I know that they can be difficult at times, uncomfortable, certainly awkward. But that's why it's so important to think about when you're electing your officers, that you elect somebody that is going to have the ability to do that when it becomes necessary. If that doesn't work, recess the meeting. Kind of the same with audience members. If you have a disruptive audience member who is not heeding your warnings, recess the meeting. If that doesn't work and the board member continues to act out, adjourn the meeting. I think that's how you deal with it at the meeting. And then the other thing you have, sometimes just calling a board member, putting it on the board agenda, calling out a board member, allowing the board to discuss the board member's behavior in the public. Sometimes kind of that public shaming is just the right, anecdote to, or excuse me, the right solution to the problem. But that doesn't always work. And in those situations, even if you publicly censure them, which is essentially kind of a public slap on the wrist, a public calling out of improper conduct, if that doesn't work, that's when it becomes difficult. Unfortunately, and I don't say it's fortunate and unfortunate, depending on the circumstances, but board members don't have the power to remove each other from the board. You don't have that power. But your community does through the recall process. And I will say that oftentimes the community will recognize that board members' conduct and eventually it will come back to bite them, sometimes through the recall process. But some things that the board can do is if that person is an officer, a vice president, president, whatever, the board can remove that board member from that position. And so that's something that you can do as well. So those are tough situations and they're sometimes really difficult to deal with. Whoops, sorry, hit my mouse there. Any other questions? Other thing I'll mention in response to that question, our office provides board trainings. Our executive director, Alexis, often will go out to a district when maybe a board is having some difficulty getting along, or there's just a lot of division on the board, or maybe the board and the administration are having a tough time communicating with each other or just not in sync. We offer board training on boardsmanship and we'll come out and kind of assist the board directly with those issues. So that's something to consider if you're having a board member or two that are just always seeming to be disruptive or to just kind of not moving along with board business and you're having some trouble. That might be an option to think about as well. There are, for particularly egregious conduct, there are provisions in the Century Code for the governor to remove a board member if there's fiscal inaccuracies that maybe a board member is responsible for. There's the ability to suspend a board member in a particular situation, and that has occurred in recent years on a number of boards. So that's an option, but that doesn't really cover the board member who's just kind of being a jerk and not acting with good boardmanship at a board meeting. It doesn't look like we have any other questions and we're at our time to end. Thank you so much for those who called in today and participated and for your questions. Our next Lunch and Learn is scheduled for September 15th at noon again. That is going to cover evaluating your business manager and some good pointers on that. Chris Ann Norby-Johnner, she's an attorney from Vogel Law Firm. We've had her speak at a number of our different Lunch and Learns and seminars and conventions. She's great. She'll be leading that discussion and giving our boards some good tips. If you need more information, you can access that on our website, and that's where you go to register as well. I guess that's it for today. Thank you so much, and we'll see you next month.